Namaskar, I am Indrajit Narayan Singh from YouTube. I am giving you landmark judgment of Sarfaesi Act and Recovery of Debt Act, Recovery of Debt Due Act 1993. Serial number 2. Course title of judgment: TRANSCORE versus Union of India. Decision and decided on 29th November 2006. Issue: simultaneous proceedings under Recovery of Debt and Bankruptcy Act and Recovery of Debt Due Bankruptcy Act 1993 and Sarfaesi Act 2002. आज मैं हिंदी और अंग्रेजी दोनों में आपको बताने की कोशिश करूंगा सरफेसी एक्ट और रिकवरी ऑफ डेप्ट ड्यू बैंक एक्ट 1993. सुनिए, ध्यान से सुनिए, कॉपी कलम लेकर सुनिए. In this judgment means Travancore versus Union of India में. In this judgment, the following important issues come to be considered by the Honorable Apex Court. First, whether the bank or financial institutions having elected to seek their remedy in terms of rddb and FI Act 1993 can still invoke the provisions of the Sarfaesi Act 2002 for realizing the secured assets without withdrawing or abandoning the original application filed before the DRT under rddb and FI Act 1993. मैं यहाँ पर आपको धीरे धीरे एक्ट के बारे में बताऊंगा, धीरे धीरे डिसीजन के बारे में बताऊंगा, और ये सारे डिसीजंस अंग्रेजी में हुए हैं, इसलिए मैं कोशिश करूंगा कि अंग्रेजी में ही बताऊंगा आपको. वेदर सेकंड है, वेदर recourse to take possession of secured asset of borrower in term of section 13(4) of Sarfaesi Act comprehend the power to take annual possession of the immovable actual possession of the immovable property. The Honorable Apex Court held withdrawal of the original application OA pending before the Debt Recovery Tribunal is not a precondition for taking action under Sarfaesi Act. It is for the bank or financial institutions to exercise its decision, its discretion as to case in which it may apply for leave and in cases where they may not apply for leave to withdraw. We do not wish to spell out these circumstances because the said first provision, the section 19/1, is an enabling provision, may deal with myriad circumstances which we do not wish to spell out herein. It was held that the Honorable Supreme Court that the rddb Act and FI Act and Sarfaesi Act do not provide parallel remedies. Sarfaesi Act is treated as an additional remedy which is not inconsistent with the rddb Act and Financial Institution Act. Together, they constitute one remedy, and therefore the doctrine of election does not apply. It is open for the bank or financial institutions and the Sarfaesi Act. The secured creditor can invoke either of the two enactment, that is rddb and Financial Institution Act and the Sarfaesi Act, or both. The Honorable Apex Court observed that the authorized officer is like a court receiver under Order 11 Rule 1. Order 11 Rule 1 of the Civil Procedure Code. He can take either symbolic possession and in appropriate case he can take actual possession. The authorized officer is under Rule 8 of the Security Enforcement Rule as greater power than even a court receiver, as security interest in the property is already created in favorable the bank or financial institutions. That interest need to proceed. Therefore, Rule 8 provides that till issuance of sale certificate under Rule 9. The authorized officer shall take such steps as the deems fit to preserve the secured asset. There is no dichotomy between symbolic possession and physical possession. आप मेरे चैनल को लाइक करें, सब्सक्राइब करें, बेल आइकन दबाएं। मेरा ये लैंडमार्क जजमेंट CIIB JIIB परीक्षा और लीगल परीक्षा और IAS की परीक्षा में, सिविल सर्विसेज की परीक्षा में उपयुक्त होगा। आप इसे सुने, जानें और समझें और सब्सक्राइब जरूर करें।